Okay, let's say you live in California, Stuart, and let's say that you were the beneficiary of a trust, but your parent passes away and you get a copy of the trust and there's several amendments and it turns out that you've been entirely disinherited. You're getting nothing. Can you do something about that, or do you have to live with that result that you've just been disinherited?
You can do something about it.
All right. Well, let's find out what can you do to try and change that result?
Well, first and foremost, this is one of the shortest statute of limitations I'm aware of. And Keith, the statute of limitations means that you have to beat that date to the courthouse with a filed lawsuit. And if you don't, you're forever precluded from bringing that lawsuit forward. Here in trust, I receive a copy of a trust or I receive the restatement or the amendments. I'm going to receive this thing called statutory notice, and that's under probate code 16061.7. That's 16061.7.
Got it.
And statutory notice just says, hey, you've been given notice. We've given you a copy of the operative document, the trust here, the restatement, whatever it is. You have 120 days from the date that's on the notice. Okay, you have 120 days to challenge this trust as being invalid for whatever reason you think it might be invalid for. And if you don't file within that 120 days, then you're precluded forever from filing. And so don't show up to a lawyer at day 119 of that 120 days and say, hey, I'm ready to file a trust contest or whatever the case may be. It's too late. You got to immediately go see a lawyer if you receive the statutory notice and you find out that you've been disinherited from the trust, especially if you had a reasonably good relationship with your parents during their lifetime, especially if you understood that there was a trust that had been in place for many years that gave everything equally to all of the children, including yourself. Those are red flags. And you say, hey, wait a minute. Why is this restatement dated, 4 months before my dad passed away, or sometimes 2 weeks before mom passed away? And it basically takes me out and gives everything to my brother or my sister. How did that happen? Those are red flags. Make an appointment and go see a lawyer early, and then you can determine how best to move forward.
So what are some of the legal claims that you have to bring in order to try to contest a trust or a trust amendment? Can I do it just because I don't like the result and I don't agree with what my parents did?
Well, you can't do it just because you don't like the result, but if you use these claims, well, then I guess you can. So let's talk about the claims. And the most important one is undue influence. And so if there's an exercise of undue influence, let's say that your bad acting brother or sister lived at home and you're a doctor, you're an engineer, you're a professional, you've gone on and done great things in your life, but you kind of have a loser brother and sister and they've lived with mom and dad for the last 20 years. And 2 months before mom passes away, there's a sketchy looking amendment that's provided to you that shows that everything goes to your brother, your sister, and you're not getting anything. You might want to be thinking undue influence. And the problem with undue influence claims is nobody ever writes an email saying, I'm planning on unduly influencing my mother to give all the trust to me and excluding my rich brother who lives up in the Hollywood Hills. And, I don't think he deserves anything. Well, we want to give what mom or dad wanted to give to everybody because we want to look at their intent. And so if somebody overcomes that intent, if somebody overcomes the ability of a mom or dad to resist the persuasion that this person is exercising on them, and they get mom and dad to do something they normally wouldn't do, and it benefits themselves, well, that's an undue influence claim. That also leads into financial elder abuse, which is a civil cause of action and has a right to a jury trial in California. And that would be somebody abusing an elder financially or through a donative transfer, such as a trust or a will. If there's financial elder abuse, it's based on the same type of undue influence that the plain Jane undue influence claim is based on. So you would typically bring an undue influence claim and also a financial elder abuse claim based on undue influence. You can do duress and fraud, and there's all other sorts of claims that might fit your particular story and scenario, but most cases are going to be undue influence, financial elder abuse. There's also a Penal Code 496 civil cause of action that some lawyers have gotten excited about lately. Supreme Court in Siri versus, I can't pronounce the rest of the name. It's a Supreme Court case in California. It says under Penal Code, that's right, Penal Code 496, you have a private civil cause of action against somebody, and you get treble damages under that statute. The one other thing that people typically will include in a trust contest is a lack of capacity claim. Lack of capacity is harder in California, but it's typically included because if somebody did lack the requisite capacity to create a trust or a will, especially if a doctor has already determined that by way of a letter in their medical records, then you can use that to show that this was clearly a product of undue influence, and it might also be a product of somebody signing something when they didn't have the requisite capacity to do so.
So when you're bringing a trust contest claim against a trust or a trust amendment, do you find that undue influence is typically a better argument than lack of capacity, or do you like the lack of capacity argument?
Well, undue influence is easier to prove to a judge at the time of trial, but lack of capacity has its place, and also lack of capacity facts that support a lack of capacity claim can also dovetail nicely with the undue influence claim. So lack of capacity, that's going to be probate code section 810 at SEC. There's a bunch of rules in there. You're going to have to get an expert. You're going to have to get some kind of a physician, a geriatric physician, a psychiatrist, and they're going to do a forensic review of all the medical records, which for an older person can be quite voluminous. And they're going to really make two determinations. They're going to say, hey, was this person susceptible to the exercise of undue influence? That's the main assessment they're going to make. And if they do come to the conclusion this person was susceptible, they have to back their opinions up with the medical records. They have to show in the medical records, dementia is mentioned, a million times, or Alzheimer's is mentioned, or cognitive impairment, or somebody took a mini mental status exam and they failed it completely. Those are issues that all go to whether somebody's susceptible to the exercise of undue influence. So those experts will show up to trial, and it's crazy, Keith, because when we hire experts, they say one thing. When the other side hires experts and they look at the same medical records, they come to exact opposite conclusions. So then it's up to a judge to determine which expert is more credible based upon the evidence.
Well, it sounds like there's quite a few legal grounds, but it also sounds like it's quite complicated. So it might be a good idea to consult with a lawyer and hire a lawyer to actually bring a trust contest claim in court. Would you agree with that?
I would. I tell clients, a lot of people are using ChatGPT now, which is fantastic. And they've been using Google for years, and they come in and they meet with you, and they've done all their due diligence. They've studied on their own. And the only thing I say to them is, look, if you needed brain surgery, I'm sure your well-meaning uncle who looked up on ChatGPT how trust contests work, he probably got in the ballpark and explained to you why you need to go see a lawyer. But would you trust your uncle to do brain surgery on you if he ChatGPT'd brain surgery or Googled brain surgery? Probably not. You're probably going to pick somebody that knows what they're doing. So it does help you pick an expert, figure out the business arrangement. It's never fun to figure out how you pay somebody to get through these things. There's always a way. And then once you have somebody, make sure that they're good, they're qualified, they know what they're doing, they care about you, they want to do a good job in your case, and that they're an expert in the field. They actually are a brain surgeon or a heart surgeon or whatever it is that you need, rather than relying on, I'm going to go to court myself. I think I can learn this myself. Don't do that. Hire a lawyer. This is a complex area of the law.
Even if you stayed at a Holiday Inn Express, you still should probably hire a lawyer. Well, that's a lot to think about, Stuart. I appreciate you sharing all of that. And if you have any questions about a trust contest or trying to contest a trust amendment, feel free to reach out to us.